If there is any problem, okay, if there is any problem during the session, you may please address that. So in today's session, I will be your host, and my name is Kevin. Um, so we know that for the past 1 week, we've been going through this faculty development program. And however, this today seems to be this happens to be the last day of the session. So in this session, we will be giving more importance to most of the teachings that has been way before all these subjects. Okay, so moving on to today's session. However, besides all these things, I would like to mention that we know that for the past 1 week, we've been through a lot of series of lectures and programs. And I hope these programs and lecture series have enlightened you in somewhat another way, so as to make you understand about the past topics and also any series of topics that is being discussed here today. So before going any further with the proceeding, with the lectures, I would like to instruct everyone to mute their mics so as to avoid certain noises or disturbances between the session. But in case if any sort of questions may arise during the meet, you may please proceed with the instructions of the lecturer. So I'm not delaying the lecture anymore further. So with this, I would like to invite Dr. Rashid T. Hamid, um, assistant professor of Al Azhar Law College, to provide the welcome speech to all of you. Ma'am, you may please take over from here.
Yeah, good morning, everyone, and a warm welcome to the valedictory session of the 7th International Faculty Development Program on Legal Research and Pedagogy in Changing Era. I'm honored to be here to extend a warm welcome to the distinguished guest, Professor Manoj Krishna. I hope your presence makes this program even more special to me, as he's a teacher of mine at the Government Law College, Trivandrum. I'm very happy and grateful to have him as a resource person. He will be delivering a speech on the topic Unique Challenges in Legal Pedagogy, Past and Present Responses, a Realistic Perspective. Welcome, sir. I also welcome all the faculty members, research scholars, and participants to the program. We always value your active participation in thought-provoking interactive sessions during the session. Thank you.
Thank you.
Go to Kevin give the introduction for the resource person.
Thank you, Hind ma'am, for the speech. So now moving on with the topic. Today we have a eminent personality here. So moving on with this, I would like to brief you on about the person who is addressing today's topic. So first of all, his achievements will be brief now. So here, during his achievements, as we go through this, we can find out that he's done his bachelor's in LLB from Kerala University in the year 1990. After graduation, he did his post-graduation in LLM from Kerala University in 1993. He was a first-rank gold medalist. After that, he went on working for as a former member of adjunct faculty of Asian School of Business, AITTS, and also he was a member for Future Studies Department at Kerala University. He was also a former resource person of HRDC, University of Kerala, IMG, and also Police Training College. He was a member of Board of Studies of Kerala University, Calicut University, and Kannur University. And he was a professor at Kerala Law Academy Law College and also Government Law College, Trivandrum. Presently, he's retired. And besides that, he has chaired and participated in more than 25 nationals and international seminars. He has presented papers and published more than 10 papers in national and international journals. So, without further ado, I would like to welcome Professor Manoj Krishna to deliver you a speech or give you a lecture on the topic related to today's session. It is related to the unique challenges in legal pedagogy, the past and present responses. It's a realistic perspective, so I hope you all understand uh, today's session and go through every necessary details if required. And if any question seems to arise in between, you may drop your questions in the comment section. And if any more further um, information is needed, you may please turn on your mic and ask us relating to such matters. So I welcome you, sir, for delivering the lecture for today's topic. You may please take on today's session.
Can I start my session in?
Yes, sir. Sure.
So, a very good morning to you. Am I audible for all the participants? I hope I am audible to you. What is your response?
Yes, sir. You're audible.
Am I clearly audible, Sri Priya Prasad?
Yes, sir, you are very much audible.
The problem is that with regard to what you had, the very kind words of introduction given by Mr. Jubi, I suppose. I couldn't hear a word of it. Because I think there is some problem with the settings in my device. There is some problem. I can hear it only very feebly. So hopefully by the time, when there is the time for interaction, interactive section, you will be able to put in a little more sound in your devices so that I can hear it. The only two videos which are on are both my students. One is Hind and the other is Repriya Prasad. And I taught them maybe a gap of 10 to 15 years. Hind was my first batch at the Government Law College, Trivandrum. And Sri Priya was one of my last batches at the Government Law College, Trivandrum. Before that, I was in Calicut Government Law College, and before that, in Law Academy. At the onset, I'll tell you something about teaching as it is before I come to my topic. From morning to evening, dawn to dusk, you are teaching or you are being taught. You just watch it. The parents teach the children their word. The teachers teach their students. The doctors teach the patients. And the husband tries to teach the wife. And finally, the wife will teach the husband a lesson. You are all teachers, most of you are research scholars. There is a joke that it is better to have a teacher as your wife. Teacher. You know why? Because she won't let you sleep without doing the homework. Homework cheyipikada orakathilla teacher aanu. So it's a joke like. So the thing is, you are full of teaching, dawn to dusk. And similarly, the world is full of teachers. From the lower kindergarten teacher to the professors of college, the deans, so many of them, from Swami Isha Foundation of the Isha to Sri Shankaracharya, Sri Narayana Guru, to Buddha, to Jesus, to Nabi, the Prophet, all were teachers. So the world is full of teachers of different grade. There is a novel written by O.V. Vijay, which says that there is an ocean of teachers in the universe. Everyone is teaching something to another. The trees are teaching something to us. The animals teach something to us. So the novel is Guru Sagaram by O.V. Vijay. That is the ocean of teachers. So coming to from our concept of teacher of or omnipotent, omnipresent teaching and teachers, we come to my talk. My topic is, as already the research part of your sessions are finished off by so many of the presenters. Many of my friends were there. My colleagues were there, my teachers there were, my students were there as your resource persons. Now my topic is uniqueness of legal pedagogy. Uniqueness of quote unquote legal pedagogy. Now legal pedagogy can be interpreted in different ways. So that's why I said it is uniqueness of unique challenges in quote unquote legal pedagogy. Now here, the responses are realist perspective. Now, what is the uniqueness with regard to law teaching? Now, uniqueness with regard to law teaching can happen out of three counts. One, the subject of law is itself. It is very unique. It cannot be compared to other subjects. So that is one uniqueness of our profession. Secondly, the pedagogy. That is the skills, the tools, and the methods which you use to teach them. That is also different. To be effective, that should be different. Third, the category of students to which you are catering. That's the most important of it. Now, law students, when you are teaching law students, you have to understand that at a later stage, they will be judges, they will be legislators, they will be in very technical and very key position in the polity of a country. For example, I was teaching for more than 3 decades. That's now 31 years since I have started teaching law. Within this short period of, not short period, long period, because many of you are less than 31. That is, I started teaching even before you are born. See, in my student group or among my students, there are 3 judges of the High Court. Jayachandran, Basant Balaji, Raja Vijayaraj. He was not a old-time student. I was there to invigilate. Then I have more than 25 district judges. Not 25, more than 30 district judges who were my students. An innumerable number of municipal magistrates. Now, whatever values you communicate to them as a teacher, that will be affecting their job, or that will be affecting their, or will be seen in their judgment and the way they decide their things. So unknowingly, you are going to affect a huge number of people. We may not be conscious of it. So it is our duty to give value education to the students so that when they reach higher echelons in the society, they are able to provide or deliver justice in the right perspective. So this is the three counts on which I see law teaching and legal education is unique. Now, first of all, I'll come to the subject of law and the uniqueness of the subject. Now, you know, law is a very confusing and confounding subject. The general public is always, what do you know, see, so full of contradiction that the general public has different opinions with regard to law. They can't understand the proper functioning of it. See, law is a subject on which every Tom, Dick, and Harry talks. Everywhere. You can see persons in the market, persons in the barber shop. They are all discussing heavy legal issues. Barber shop is okay. Why Devan Ramanandran making such a hue and cry? Can't he not keep his restraint? So everywhere people criticize law, lawyers, etc. Is it true, Hind? What is your opinion? Sri Priya, what you say?
Yes, sir.
Right. Everywhere people have discussing, criticizing everything, like why Madani is there, why all these things are there. But at the same time, yesterday there was a cleaning in my house, and all the dust got in, and I am having a wheezing problem. My wife was teaching me a lesson. Now, everyone criticizes lawyers, but you get a piece of paper from a court. In some house, you get a piece of paper, let alone a warrant, a summons. But in the ഒരു summons വീട്ടിൽ വന്നാൽ അവിടെ വെച്ച് ഈ ധൈര്യം, then you are upset. You don't know what to do. So the first time in my family, court process is coming. Where should I go? Which lawyer should I meet? Then you are upset. You run after the lawyers. There is a saying that you respect a lawyer only when you need one. Avisham veribade. Sorry, I'm very sorry. Having a now, if you ask Dilip, who is the greatest person in the world, undoubtedly he will say that is Advocate Ramanpillai. So a person respects a lawyer only when he needs one. So you see, the people take law for granted. At the same time, they have a fear of law. Now, why this fear of law? The root of every fear, if you analyze fear, if you analyze fear, we can see that the root of every fear is ignorance. The fear of the dark, the fear of the unknown, the fear of the death. Why we are afraid of it? We are afraid because we don't know what will happen after death. We don't know what will happen in the dark. So the cause of every fear is ignorance. The modern people, not modern people, the people of this country, the common ordinary man on the street, he is afraid of law. Why he is afraid of law, including the law teachers? I know in government law college, there are regular student problem. Even now we had one. I'm retired, but I'm still in touch with them. And none of the teachers are willing to go as a witness. After all these studies, after teaching all these things, the teachers, even the teachers are not willing to go as a witness. Why? We don't want to get entangled in law. So there is a fear of law. This fear of law is created by misconceptions, confusions about law. This confusions of law exists among the common people, the professionals like doctors, engineers, and lawyers, and even those who teach the law. I'll tell you an example. These misconceptions are created mostly by the media. If you go and see the serials of films, you can see that an accused person like Amitabh Bachchan or Mammootty, how he is shown in a film, he will be in a cell. Is it not? He will be in a cell and he will be standing there, and the prosecutor, that will be Suresh Gopi or Sai Kumar, or someone will come and say, what were you doing? So the person who is in the cell, Mammootty will say, I didn't do that. Now, whether such a thing will ever happen in a court, the chances are 0.1%. Because in a court, it is not the accused person who is cross-examined. The accused person is never cross-examined. Only possibility is that, exception is that, the accused says that I want to be a witness. And he comes as a witness for the accused. Then the prosecution can do it. You watch the Dilip trial. Pulsar Suni won't be cross-examined. Dilip won't be cross-examined by the prosecution. Because under Article 20, Clause 3 of the Constitution, no person accused of a crime can be compelled to be a witness against himself. That is the rule of self-incrimination. You all study. So in a criminal trial, accused can be a witness only when he condescendingly becomes a defense witness. Otherwise, he cannot be made a witness. So in the Dilip trial, Pulsar Suni or Dilip will never be cross-examined. But who was the persecuted woman, actress? She is the witness. So she was cross-examined. She was grilled. She complained about the court. She complained about the prosecutor because the witness will be harassed, grilled. But persons are waiting for the cross-examination of Dileep's cross-examination, which will never happen. One day in the Madhurabhumi paper, I saw a heading. Dileep in the cross-examination മാറ്റി വെച്ചു. Dileep in the cross-examination മാറ്റി വെച്ചു. So I got amused. Why this is going to happen? I went through the paper. അപ്പൊ അതിനകത്ത് എഴുതി വെച്ചിരിക്കുന്നത് എന്താ അറിയും? ദിലീപിന്റെ വക്കീല് നടിയെ ക്രോസ് എക്സാമിൻ ചെയ്യുന്നത് മാറ്റിവെച്ചു. ദിലീപിന്റെ വക്കീല് he will be cross examining the actress. അത് മാറ്റി വെച്ചതിന് ടൈറ്റിൽ കൊടുത്തിരിക്കുന്നതാണ് ദിലീപിന്റെ ക്രോസ് എക്സാമിനേഷൻ മാറ്റിവെച്ചു. So what is the concept or what is the perception of the people who watch? I get the feeling that Dileep is going to be crossed. The only person who can ask questions to Dileep is the judge. That is called a 313 statement. And when that statement is being used, there also Dileep is not in the form of a witness. He cannot be put in oath. He cannot be compelled to answer a question. He can keep mum. That is only the judge trying to get the matter from. On the other hand, the prosecution cannot compel Dileep to be a witness. So, see, these type of misconceptions exist among the public and also among the law students. I was there as a subject expert for the last PSC recruitment of law college teachers. So we had teachers from every colleges. Then we had also fresh graduates. And I was surprised to see when I posed this question, many of them were uncomfortable. It was a PSC selection for the post of law lecturer. But thank God, when I was acting as a subject expert for the PSC for the post of assistant public prosecutor, not this time, last time, then the people, the advocates were more aware of it because they are seeing it and feeling it. So the concept is that in law, you have such confusions for the general public and also for the lawyers. Now, when you take, as I told you, law as a subject, there is another certain unique features for law. One is that there are no answers in law. There are no answers in law. As a teacher, you should be aware of it. That is, when you get a problem and the students have to answer the problem, you say that was the right answer because that was decided by the court. But you know that this decision of the court can be overruled tomorrow. Now, in Raghunath Nagabhushanam's case, the Supreme Court held that right to life under Article 21 includes right to die. So we were all teaching in the class that right to life under Article 21 includes right to die. But the next year in Gyan Kaur, it was overruled. And the court held that right to life can never include right to. So there is no perennially true answers in law. നിയമത്തില് ശാശ്വതമായ ശരികളൊന്നുമില്ല. What is right and wrong will keep on changing. Will keep on changing with regard to the perspective of the court and perspective of the different judges. There are no answers in law. So when you give a problem, if a child is not coming to the right answer, according to the latest judgment, he is able to rationalize his case, you should give mark. Now, why this problem of confusion in law and no answers in law? Why is that there is no answers in law? See, there are no answers in law and confusions in law of two count. One, semantic fertility. Julius Stone says that it is semantic fertility and limits of logic. Semantic fertility means law is made up of words, and words can be interpreted in one way or other. When Hind Rashid was studying, I think I was the teacher who taught them interpretation of statutes. And I still remember another teacher was allotted the subject, and the children from this class went and complained to the principal that they want me to take the class. That is one of the earliest recognition I got from the government of they wanted. Yes. So I first took the class, then another teacher, senior teacher came. Later I was called back. K.S. Ajay Kumar, who was the first principal of your college, was then the principal of government of college. So in interpret, see, words can be interpreted one way or another. They say paternity is a belief and maternity is a matter of fact. അച്ഛനുള്ളതൊരു വിശ്വാസമാണ്. പിന്നെ വലുതായിയൊക്കെ വരുമ്പോ അച്ഛനെ പോലെ മോനെ ഇരിക്കുമ്പോൾ ഉറപ്പിക്കാവുന്നുള്ളത്. But maternity is a matter of fact. അമ്മ എന്നുള്ളത് it is a fact. വസ്തുതയാണ്. But in law, even the concept of mother can be confused. The concept of mother can be confused. For example, if you take a in utero baby, what do you call a test tube baby, a surrogate mother. Who is the mother? There is a surrogate mother who is the biological mother. There is the lady whose ovum was taken, who is the genetical mother. Actually, the lady, the child is used in the test tube. So, test tube. So, it can be the biological mother, it can be the genetical mother, or even the test tube. Who is the mother of a surrogate baby? If you have not read it, please read the Yamada Manchi case. A very sensational case. The Yamada Manchi case. Then you will know even the word mother can be interpreted in so many different ways. So, the problem here is that when, as a teacher, you teach the subject law, you will be asked to teach contradictory observations in the class. One day you have to say that right to life includes right to die. Next day you have to say it doesn't. No, the children are confused. See, what is there? What is the right thing? That's why I said there are no answers in law. You see, Justice Garnett, a judge of the one High Court, wrote a letter to the Honorable Chief Justice about some grievances. And this letter was considered to be a contempt. And the poor Chief Justice was put in prison for 6 months. Because under the Contempt of Court Act, the maximum punishment which can be given is 6 months. On the other hand, Prashant Bhushan vilified the Supreme Court, attacked the Supreme Court, put the photographs of the then Chief Justice, making humor and fun of it. A contempt was moved. And what was the punishment given? What was the punishment given in Prashant Bhushan case? Do you remember?
A fine of 1 rupee.
Anyone remember?
Fine of 1
A
rupee.
fine of 1 rupee. A fine of 1 rupee. Maximum punishment under the Contempt of Court Act is 6 months. In Vinay Chandra, Bar Council chairman made some scenes in the court, and he was punished with, I'm not very sure, 6 years or 2 years of imprisonment. If the Contempt of Court Act says that the maximum punishment is 6 months, how did the Supreme Court do that? It's open for you. You find out the answer. So the thing is that when you deal and teach cases, you will be forced to teach very contradictory manner. That is the uniqueness of the subject law. And you will also be forced to teach them logic, because law is made up of logic, and different answers are reached by the judges through logic and semantic fertility. The logic and semantic fertility random kondana judges kalichu avarku thoniya judgment. That's what Julius Stone says, limits of logic. See, the logic has no sense. We say that the basis of everything is the logic, but logic has no sense. Sometimes, see, 1 + 1 is equal to 2, usually. But when one river joins with another river, it is not 2. It's a big river. Vaikam Muhammad Bashir പറയുന്നത് പോലെ ഇമ്മിണി വലിയൊരു ഒരൊന്ന് വേറെ ഒരു ഒന്ന് കൂടി ചേർന്നാൽ ഇമ്മിണി വലിയൊരു ഒന്ന്. So these are the constraints of logic. While going through the argument of Shabarimala decision, Justice Parashar, he briefed the court. See, judges, honorable judges, in a case, if you ask the right question, you get the right answer. You ask the wrong question, you get the wrong answer. He's talking about logic. ഒരു കേസില് കൃത്യ ചോദ്യം ചോദിച്ചാൽ കൃത്യ ആൻസർ കിട്ടും, തെറ്റായ ചോദ്യം ചോദിച്ചാൽ തെറ്റായ ആൻസർ. And he illustrates it. The illustration is like this. If somebody asks someone, ഒരാള് മറ്റൊരാളോട് ചോദിക്കുക, can you smoke while praying? നമുക്ക് പ്രാർത്ഥിക്കുമ്പോൾ സിഗരറ്റ് വലിക്കും. When you pray, can you smoke? Hind, what is your answer?
Of course, no, sir.
No. Is it not? While you are praying, can you smoke? Generally.
No,
No.
sir. No.
ശരിയല്ലേ കാര്യം, നമ്മള് മാതൃകാപരമായിട്ട് ഒരു കാര്യം ചെയ്യുമ്പോൾ വലിക്കാൻ പാടില്ല. You ask the question in a different way. While smoking, can you pray? നമുക്ക് സിഗരറ്റ് വലിക്കുന്ന സമയത്ത് പ്രാർത്ഥിക്കാമോ?
Yes.
Yes. But in both the cases, what is there? Prayer is there, smoke is there. No, Parasharan's claim was the question asked by the judges in the Shabarimala decision was whether the woman is being discriminated with regard to the entry to the sanctum sanctorium of Sri Ayyappa. That was the question, one of the question posed. And according to Parasharan, that was not the right question. The right question was whether the idol called Shabarimala Ayyappa had a right to limit the person entering into his property. That would have been the question. That was his argument. So again, the second point which you have to keep in mind when you teach law is that law is full of such contradictory decisions. 1 year before, I was teaching Rahul Ishwar for evening classes in Law Academy. You know Rahul Ishwar? Rahul Ishwar. And he is a born, very inquisitive person. But after some time, he understood what are the defects of asking questions. Especially when you are asked questions in the classes, there can be 3 types of questions. One, there are persons who want to catch your attention. It is for the teachers. Some students want to catch attention, so they ask questions. Some of them genuinely ask questions. But the thing is that even when you are genuinely asking a question, the person who asked the question has an answer with them. And what he wants that the teacher should give that answer. If the teacher is not giving that answer, he will come with another question because his doubt will still be there. So there are so many techniques to evade, not evade questions. Like you should not allow the questions to get interfered with the normal flow of the class. It can be done by providing some time for persons to ask questions. If there is a lack of time, you can even ask him to come to the staff room and clear questions. This is a practical aspect. So these are some problems with regard to the subject. So law is a very unique subject. Another aspect of law is that teaching law is a science as well as an art. Now, with regard to science, when you teach science, you are teaching facts. Scientific facts are universally true. If you are teaching, say, Avogadro's principle or a principle of conservation of energy, total momentum of the colliding bodies after collision and before collision are equal. You can prove it universally. If a collision happens in Alaska also, it will be the same result. If it happens in Haiti or Guatemala or Colombia or Italy, everywhere it is true. So these are facts which you communicate. It is very easy. So in mathematics and all, you have to derive things. That is something a little confused. So in law also, when you are teaching the sections, the provisions of the Indian Penal Code, if a person commits murder or culpable homicide, there shall be life imprisonment or death penalty. These are all facts. You just teach them the sections. So it's only a science, it's more of a science. Section 2D of the Contract Act says that if at the desire of the promisor, promisee or any other person has done or abstains from doing, does or abstains from doing, or promises to do or abstains from doing, then such thing is the consideration. Section 2D of the contract. So you have to just explain what are the ingredients of it. So this is one part of it. But when you have to teach case laws, there you have to work as an artist. First of all, a case law will include contradictory aspects. Just like no person shall be deprived of his life and personal liberty except according to a procedure established by law. And this article was included or interpreted. So many things were interpreted in the word life. Right to privacy, right to health, right to free and fair environment, pollution-free environment, right to livelihood, right to education. So many of them were read into just the word life under Article 20. And finally, it culminated in right to life under Article 21 includes right to die. Now, when you teach it in the class, you have to both prove that it includes right to life and also it includes, it does not include right to life. Because there are two conflicting decisions. So when you teach case laws, there you have to work like an artist. First of all, you have to bring the child to think with you. You should also apply his mind. So when you teach cases, teach them in an interesting manner. Other day, Justice Rohington Nariman was speaking, and he was saying that when he studied in campus law center in Delhi, he said that even though Carlyle versus Carbolic Football Company, a case in company contract law, was taught to him by a very junior teacher, he still remembers the case. The simple reason is that the facts are so interesting. So as a teacher, when you teach law, take cases whose facts are very interesting. And the fact itself will lure the student to study more. Plus, whenever you teach something in class, the case law, make sure you say some history. Every case will be like a story. There will be a storyline. You can develop the story in a case law like a story, because the most effective way of communicating throughout the world is through stories. Every big communication, say Mahabharata, Ramayana, Bible, every great works have sermons, but they are communicated through various stories also. So when you teach, Keshavananda Bharati was the state of Kerala. Some say that it is not Keshavananda Bharati was the state of Kerala. There was a case that it overruled Goraknath case, and the basic, the concept which was evolved was the basic structure of the constitution. You have to leave that. You study the basic facts in Keshavananda Bharati, so that these factors will be interesting for the students. Just like in Keshavananda Bharati, it was a 13-member bench. There was Shalath, Hegde, Grover, Khanna, so many of them. And the purpose was to overrule the Golaknath case, because in the Golaknath bench, there was 11-member bench. So in Keshavananda Bharati, what happened was, there were 6 members in favor of the individual rights and 6 members in favor of regulating the individual rights and the power of the parliament to regulate. And there was Justice Khanna, who neither that joined that side or the side. And finally, by fate, the judgment of the Justice Khanna became the majority. It is celebrated at a great case, but when you analyze the case, you can understand that there is nothing in this case rather than creating confusions, No contributions, but it is celebrated. When everyone celebrates, everyone celebrates. We too celebrate. So when you deal with such aspects in the class, it will motivate the student to study the case more deep and to criticize it. This is what is lacking in our law schools. Justice Chandraju, the current Chief Justice, was speaking. He said that there are methods and methods for creating good lawyers, but we are yet to have a process or not able to create great teachers. Unless the teachers become great, it's very difficult for the student also to become great. So primarily, we have to have a good knowledge of what we teach. We should try to acquire the history and all these things. And we should make our classes more effective. One is the method of giving case laws and all these things that you can make effective. Then you can purposefully give jokes, add jokes and all these things. I'm talking about the lecture primarily, but it can be used in any classroom. And the Chief Justice was giving an example. A junior lawyer once came to the court. Are you hearing me, or most of you have switched off and got to sleep? I can't see it because you have all switched off your cameras. None of you have. Okay, so Sri Priya, are you there? Or have you gone for your breakfast?
No,
Sri
sir, I'm
Priya.
here. Yes, sir, I'm here.
Sir, we are all alert
switch on
here.
I can be very, what do you call? I was a teacher, so I have the liberty to say something to Sri Priya Prasad.
Yes, sir.
Is there any problem with the data, Sri Priya?
Yes, sir.
Otherwise, you could have switched on. Even though we don't talk each other, I keep in touch with her with daily good morning messages.
Yes, sir.
Now, say one junior lawyer once came to a court and he was just checking the gun. So the judge asked, do you want to say something to me? Submitting to submit. Then the junior lawyer said, sir, what is the time? Judge got infuriated. What is the time? What is the time? Then the judge said, why ask for time? Sir, what is the time? You ask something, what is the time? So why are you asking me? Because there is a big clock here. Huh? There is a big clock. You can find the time. See, sir, the problem is that my senior asked me to ask judge for time. The time which he meant was to adjourn the case or go for a Passover. Adjourn the case or a Passover. So the technical term is that if you want to adjourn the case, ask for time. And this boy literally took it to, what is the time, sir? See, he was telling me, this is the problem of teaching the student improperly or not properly. Not by the teachers of the college, but by the seniors, or his failure to understand it. So, this sort of thing even now are happening, and many of the bar is lamenting on the lower qualities of the upcoming lawyers, and all these things are there. So it is our duty to provide them with all these things. So this is the craft of the teacher. This is the craft of the teacher. The uniqueness of our subjects require us of so much creativity. See, the one point, all our education, I've been teaching for 31 years, even though I look young. Isn't it, Vijayalakshmi? Do I look young? I'm in 60s, going into my 60s. So, my career, see, a teacher and education system should be student-centered. That is one basic. Because without students, we never exist. And later it is through our students we are known. The Socrates was known through Plato, and Plato was known through Aristotle. Sri Ramakrishna Paramahamsa was known through Vivekananda. So it is through your Shikshas. I'll be known as the teacher of Sri Priya Prasad or Hind Rashid. So you should be giving due respect to the students. You know, whatever we communicate, actually, it is happening inside the mind of the student. Whatever you communicate is already in the mind of the student. Whatever I have told is already in the mind of Sri Priya Prasad. Only thing, I just give a signal if you get enlightened. That was it in you. It was not outside you. Whatever knowledge happens inside you is already there. The teacher's job is to kindle it, light it. There is a blast. So, if that point should be there. What we are trying to communicate is also already in some other form in you. Just like you say that in a stone hides the statue. Only when the person sculptures, chisels out the unwanted part, it becomes the form. There is a stone, a beautiful stone. But the artist sees the Michelangelo's, what do you call, Christ and the lady or something like that in the stone. What he does is to remove the unwanted part. So this you have to keep in mind, that is respect of the student is another important part. Now coming to the second aspect, that is the skills, tools for communicating legal education. There you have to understand the objective of the legal education. There are two objectives for legal education. One is the liberal view and the other is the professional view. The liberal view says that the object of teaching law is being taught like any other subject. You teach politics, you teach sociology, you teach economics. Similarly, you teach law, another subject. This is the liberal approach. On the professional hand, there is another school which says the object of law is to create legal professionals. Earlier it was the lawyers. Now it is the lawyer, the law professional like legal officers, legal assistants, law managers, legal advisors, and lawyers. So primarily, the object of law is to create professionals. This is another approach. From the liberal approach, you can see that it is studied as a knowledge, then you have research and all these things, and you go like that. You go deep into the subject of law, you bring about law reforms, you do such and such things. From the approach of the professionals, you create a good profession, a good lawyer, great lawyer. So from the angle of professional legal education, which is imparted in the law schools, it's somewhat different. The only space for professional legal education is the clinical legal education. You have subjects like the moot court, the arbitration, you have the trial courts, you have content writing, then you have what do you call drafting and conveyancing. These are all subjects which provide clinical legal education. And you also have some court work, 20 days court work. That is the existing syllabus. That was inadequate. You know that when you go for MPBS, the clinic starts after first MP or whatever it is. After the first year, the clinic starts. That is, the students are taken to the hospital. They are allowed to watch what the doctors do. They are asked to take down and they support them. But in our law schools, we never take the students to the court and you give support and all this. So clinical education has to be developed. And you have now internship, but it has become very, you just go there, you get a sign and come back with the whatever you have written and put it in here. If you're able to monitor it properly and regularly, then we can make students study something during the period of internship, if it is done properly. Then moot courts are there, it is very effective. Nowadays, the trial courts are also there. So all these things have to be worked out. Now, what is the method which has to be adopted in teaching? Conventionally, we had the lecture method. It is what still continues. In spite of the fact that we are bringing so many other things, what is continuing is the lecture method. And you have the seminars, what the teacher, a different type of teachers. I've been seeing so many teachers in government law college Trivandrum. 8 of the teachers were my students. 8 of the teachers in government law college now are my students. So I know them, they are very capable when compared to other colleges, because I've taught again in some different colleges. So what we see is that you have the seminars, you have the assignments, you have the test paper. There are some teachers who will be taking class for the majority of the time, and in last 2 weeks or last month, they will finish off all the seminar, all these things. Then that will only be a ritual. Then there are other teachers who will just take the introductory class of 3 or 4. After that, they will start with seminar. The rest of the whole session, it will be seminars. And in the seminar, it will be effective if you have a seminar where the students are dealing with the topic and there are mutually interactive section and the teachers are interfering in between and the whole thing ends up as a class. But here what we do is that every day there will be 10 persons to present a seminar. You have 45 minutes. One person will be given 5 minutes or 6 minutes. Then there won't be any questions asked. So this is the drawback of Sripriya and all were used to take long seminars. It was good. There were some children in every class who will be considering it, they will be different. First year, they will be different. They will do it proper. Second year, they will think, what is the use? Even if you do for 2 minutes, 5 minutes, mark is same. So they will also stop doing that. But we have to nurture that students and ask the other students to come to that level. That requires a lot of effort. No, we had followed the conventional lecture method, the case method, the problem method, the Socratic method, the tutorials. All these things we adopted one stage or other. Assignments can be considered to be one form of a seminar method in that sense. Or there can be discussion method, you change it into different groups. The problem is that if it's a class of 20, 25, it will be easy for the teacher to supervise all these things. But in a class of 60 or 70, it is very difficult within the constraints of the total time which is allotted to you. For a semester, a teacher will be getting something around 40 hours. And if you are properly doing the seminar, you require 40 hours or more to do the seminar itself. So it's not realistic. Then we can see the problem method we sometimes use in moot court because you are giving a problem and they are asked to present it. Only thing that is in the form of a case. So we have been using all these methods in one way or other. But still, lecture method forms the background of it. Because of the number of the students and the lack of infrastructural facilities. For example, if you go to the foreign university, you can come to the campus and work in 12 o'clock and 3 o'clock. Anytime you can work. Then there is no strict schedule for all these things. Materials are available. All such things are available. We have so many constraints. Now they are coming with so many new things are being suggested, like the flipped classroom. The flipped classroom is that the teacher will be teaching the students online. They will be in their home. So he will be giving them work to be done, how it should be done. He will be giving online classes. And when the student come to the class, he will be working on it, what is already given. Just like it is the reversal of homework that we used to give classes. In classes, you teach them and they have to go to the home and work. Here, the students are being taught in their home through online media. And they have to work it out and show it in the class. So then there is the collaborative form of education and collaborative form of education. See, when you classify into small groups, they collaborate more with the teacher. Like they present the cases, students interact with each other. Some groups are created. You ask them to interact. So they will be discussing cases between them. And with the teacher just supervises the whole thing. So new fresh ideas come. And when the students alone are there, they can come with new dimension and new things. Interactive sections are there, practical skills development. So many other skills are being tried nowadays to improve the teachers, or new techniques are coming, like the simulated course that was happened 10, 15 years ago. That is in simulated course in a court scene can be simulated in the classroom itself. And the students can take part in a court trial inside the classrooms. And they can act as a lawyer. Such softwares were developed. You know what exactly happened was, there was the lectures, everywhere there was the lectures. And the law teachers made lectures a little modern with their own gadgets. First they came with the PPP. Oh, students were taken aback. Oh, the teacher is using the PowerPoint, interesting. Then after that, there is the overuse of PowerPoint. Now nobody is, I mean, it's not very effective. It is, what is PowerPoint? They just, some visuals are being shown, that's all. PowerPoint presentation. Then there are certain small gadgets like how you can use the laser light. These are all gimmicks. More than teaching, these are all techniques to entertain the students. This can be used to entertain the students and to divert them and all these things. Now the question is, to what extent you are delivering it? You are delivering the goods. Now that after the COVID, you are in the online mode or hybrid mode. There are options available for the teacher if some students are not present in the classrooms and they require additional information. Now it's very easy. You have a Google Meet or a Zoom and you can communicate with them. Now with regard to legal research, there is a problem. That is, one problem with the legal research is that we are having hundreds of theses. But the drawback of it is that none of the theses coming from universities are of any use at all. They are never quoted. They are never referred to in further dissertations. So there is a lack of original work in research. What they do is that there is a concept. You analyze the concept. Or you take something, the effect of MTP Act in one particular year or 10 particular year. Or the effect of EES legislations on a particular area. Or you take certain concepts like right to health, various dimensions, ramifications of right to health. So many rights are coming. Now recently a right to repair has come. A right to repair. That is, you have a right to repair your phone and all this. And now that will get raised to the level of a fundamental right, because the right to repair is that modern day gadgets are so made that you have no option for repair. Use and throw. So there is the right to repair. It's yet to get formulated as a right, but the move is there. So either you research on some legal concepts which have already, even with regard to basic structure, you have dissertation, PhD thesis. What's the use? Promissory estoppel, dissertation, rule of law, dissertation. right of the state, or you take a new legislation, information technology, section 16, dissertation. So what you do is that you just compile information already available, tabulate it, just give some suggestions, make a dissertation. In India, one problem is that nowhere, even in science, pure research is not happening. And original research is happening only in some areas. And another problem is that nowadays, the robotics and the development of the computer technology makes available any data within no time. You can refer to any case within no time, which required days of research in the earlier period. So the space of the researcher is now being occupied by the computers. Last day, I wanted to get the citation of a case for my YouTube channel, which happened in the 1560. Earlier, it was not possible because you can't have a library where you have a All England report or something with 1560. All England reports are not there. But you just refer into Google and you get it. So information is available at your fingertips. So, see, ongoing, the Supreme Court had conducted a research which is more social worthy. Like, what is the effect of euthanasia on the society? More than a court coming to a decision, a research should be conducted. And Supreme Court is taking the initiative to do that. With regard to the cure right, the lesbian, gay and all, whether you can conduct a research. The Supreme Court is conducting a research. And finally, what we required is that there is a lack of inclusiveness in legal education in India, and by which a big chunk of the society is being avoided from the scenario of legal education. Chief Justice was saying other day that 87% of the students in national law schools are Hindus, and only 1.27 of them come from the scheduled caste, scheduled tribes, etc. 1.27. And the majority of the students coming from urban areas and not rural areas. And majority of them has English education. And the outcome is that only 40% of the students coming out of national law schools are going into litigations. Rest, majority is going for corporate firms. So why are the government investing fund crores of rupees in this country to provide workers for the corporate? So what is this? And further, just because of lack of English or lack of convent education, great persons in the rural areas fail to get into these elite institutions. So there is also a lack of inclusiveness. These are all certain challenges which legal education see. This is it's almost 125 minutes. I couldn't go deep because it's a very, you get bored. I know you get bored after 45 minutes. So if someone want to ask a question, I'll answer it. I'm stopping video because if I want to hear a question, I have to keep my ear very near to the device. Okay, you can ask questions.
Sir, good morning, sir.
Morning.
Sir, that in teaching, that Socratic method of teaching is, even I am, as you said, that I am going on researching here and there in Google, and I get material about that Socratic method of teaching, and start asking questions to the students, some brainstorming questions, and everywhere they come with answers, and again going with questions and having answer for myself to have a clarity in explaining them. But still, do we have a book on that Socratic method of teaching in India, sir? Or any book that you refer, especially for going for teaching law, effective one for the students, and also interesting. And I find your lecture is very much interesting, that when you talk about whether test tube baby is whether test tube is a mother. When we talk about the surrogacy or anything else, we talk about the biological mother. We talk about the one who gets adoption, that she is a mother. Or when it comes to the case of LGBTQ, whether boy is a mother or a girl is a mother, or who takes the role of the mother in that, the test tube, whether test tube is a mother. That's also very interesting one. And this guy, I hope that in future I should learn more about to make the teaching effective. So is that for the Socratic level of Socratic method of teaching, or law teaching is an interesting one? Is there any book is there? Kindly please refer, sir, so that we can also use it for a better effective teaching in the class. Thank you, sir.
Thank you, Madam Vijayalakshmi. There are umpteen number of books dealing with the methods of teaching law. Everyone has their own concepts of teaching. Because basically teaching is communication and what do you call transfer of ideas. It's an intellectual transfer of ideas. So see, there are different methods of communication. For example, they say that only when there is a communication between person, only less than 30% is communicated orally. Majority of the communication takes place through body language and some other aspects, because we all been communicated. Even though I am seeing only 3 persons, I know I've been communicating with so many participants. They are understanding what I say, but they are not talking to me. You are not talking to me, only lasting. But I know that it's being communicated because our communication daily occurs more through signs, a nod, your face, everything communicates. And some say that persons like Ramana Maharshi used to communicate without speaking. We don't know that. He just simply sitting, and the persons who come there, some idea, that's a possibility. A mother communicates to the children without a language. There is a dog in my house. We got a stray dog. We got as a puppy here. Now it's almost 2 years. We communicate so much. We communicate so much. That's why I said that there are different techniques they use of communication. Different techniques they use for communication. The techniques, like, it's almost similar with all other pedagogy, but only thing is that in legal pedagogy, what we require is that we have to make them think like a lawyer. That is the core of legal education, is to make them think like a lawyer. Once you make them think like a lawyer, how can you make them think like a lawyer? Is that, as I told you, it has to happen in the mind of the child. Whatever you communicate, it has to be, you should be tuned to him in such a way that there is some point where it happens. So there are so many, see, the person who started the case law method was Langdell. He has written lots of books. Then they have Socratean method and all is the same as started from Socrates. There are books on legal education, and for the postgraduate degree for LLM, one paper is legal education. And in legal education, there are prescribed 15, 16 books, all the same. See, you've been a teacher for a long time, isn't it? So you have your own techniques of improvising on it. Basically, I felt that a teacher is like a mahout who looks after the elephant. We know that the elephant is so big and he can literally throw the mahout hundreds of meters away. But the mahout will be saying, come here, trying to beat the elephant. Because, see, mahout has a control over the elephant. And this control is based upon love. Because the elephant loves the mahout and mahout loves the elephant. And it is that love that makes the elephant a small child. Similarly, when you enter a class, just go with love in your heart. Love your students. Once you start loving the students, whatever be the nature of the students, you can see. I've been teaching in the, Sri Priya Prasad Government Law College, all forms of students are there. They write about teachers on the walls. For the whole period of my experience, I never had a bad experience. Then, what else? I think we have already run out of time, isn't it?
There is any other queries? Participant can unmute and ask the questions. Sir, there is a question in the chat box. Please repeat the case name. I think the case you mentioned about during your session with regard to surrogacy. Person who asked the question, can you repeat?
Can you, is that a question, Hind?
Yes, it is a question.
What is the question?
Pinati Tahilnai, the participant who asked the question.
What is that?
Please ask, repeat the question.
Yes. Someone wants to ask a question, let the, right. Who wants to ask a question?
Sir, I think somebody wants you to repeat the case law regarding the surrogacy, sir.
Name of the case.
Yamada
It's Yamada Manji, Y-A-M-A. It's a Japanese lady, Y-A-M-A-D-A, Yamada Manji, M-A-N-G. Yamada Manji case.
Okay, sir.
It's a very famous case. I'll just in 2 or 3 minutes or 1 or 2 minutes, I'll tell the facts of the case. In the Yamada Manji case, what happened was there is a problem of high infertility in Japan. They don't easily get children. So what they do is that they will come to poor countries like India and get a surrogate mother. That was the policy earlier. So what they will do is that usually from Gujarat, there were so many surrogate mothers. So the Japanese couple will come who cannot bear a child, and they will have a what you call surrogate mother, and they will pay her handsomely for carrying the baby. That is the process. So Yamada, Mr. and Mrs. Yamada was a couple having no children. And the problem was that the lady cannot carry a child. So they came to India, hired a girl. Usually women of ill repute. ഈ പാവപ്പെട്ട സ്ത്രീകളൊക്കെയാണ് ഇതിന് തയ്യാറാവുന്നത്. കാര്യം എന്താണെന്ന് വെച്ച് കഴിഞ്ഞാൽ പൈസ കിട്ടുമല്ലോ, ഇഷ്ടം പോലെ പൈസ കിട്ടും, അതിനാണ് ഇവർ തയ്യാറാവുന്നത്. So they hired a lady. And the thing is that the ovum of Mrs. Yamada was taken. It was fused with the sperm of Mr. Yamada. The zygote was formed, and the zygote was put in the womb of the carrier woman. Carrier woman ഗർഭപാത്രത്തിൽ ഇത് നിക്ഷേപിച്ചു. Now everything is good. They offered a huge amount to this carrier woman, so she is happy because during that period she will get all oranges, apples, everything. Don't go outside, don't go this way, you eat chocolates. So she will be very happy. Mr. Yamada was also happy because they are going to get a child. Mrs. Yamada was also happy. ഒരു സിനിമയില്ലേ, എന്താണ്, ഒരു ജാപ്പനീസ് കപ്പിൾ ഡാൻസ് ചെയ്യുന്ന ഒരു സിനിമയില്ലേ, ശ്രീ പ്രസാദ്, നമ്മുടെ നെവിൻ പോളിയൊക്കെ അഭിനയിച്ച ഒരു സിനിമയ്ക്കകത്ത് ഒരു ജാപ്പനീസ് ആയിട്ട് ഇങ്ങനെ ഡാൻസ് ചെയ്യുന്ന ഒരു പടം എന്നൊക്കെ പറഞ്ഞു. അതുകൊണ്ട് വാട്ട് എവർ ഇറ്റ് ഇസ്. അപ്പം മിസ്റ്റർ Yamada and Mrs. Yamada were so happy because they were singing in Japanese, and all these things. They were very happy, and it went on. The lady was also happy because she was getting all apricots, all oranges, everything. Everyone was happy. But what happened after 5 months? This couple entered into a irretrievable breakdown. They had a long fight. Mr. and Mrs. Yamada had a matrimonial problem and they divorced. Now the question is, this child belongs to whom? When they asked Mrs. Yamada, she said, this foolish person's child, I never want it. I can't even tolerate this person, then how can I tolerate this child? When he asked Mr. Yamada, he also said, see, this Tadaga, I cannot bear with this Tadaga, and therefore, I don't want this child. When they asked the carrier woman, she is a very poor lady. She said that I can't even look after my child. How can I look after this child also? So this was the crux. I am not going to the final decision and all this thing. You refer and find out. So the question of who is the mother of this child? Now you have a legislation with regard to all these things. Okay, let's wind up.
Okay.
So I hope there are no further inquiries related to any questions. So moving on with the session.
1 second. In the one question came. In the present mode of teaching, I think that as long as there are 60 students, lecture method is the most effective. But you can make lectures very effective. Like some 20 minutes can be given for interaction with the students. Then when you teach, for example, when you teach a case, you can get 1 or 2 students from the class itself and make them characters. Actually, this idea I got from a lady in my class who in the course of her seminar did it. Was she in your class, Priya?
No, sir, she was my senior.
So that is good. So there can be more participation. Second thing is that you just deal with current issues. Like if you deal with the Nirbhaya case during that period, Dilip case, You deal with the latest cases with regard to the boat tragedy or the lady who was killed. And if you discuss it in connection with the corresponding laws, why FIR was not registered initially. FIR was with regard to grievous hurt and not murder. Later it was included. So when all these things are discussed, there will be more participation. But so you should apportion the lecture. If it is 1 hour into half an hour, 15 minutes classes and 15 minutes what do you call discussion on current issues. So lecture should be the core of it, because the syllabus can be finished off only by the lecture. If you take case laws, that case laws cannot cover all the topics, because in certain topics there won't be any case laws. So that is there. Okay, you can continue, sir.
Okay, so as we reach the end of our session today, I would like to welcome once again Dr. Hind T. Rashid, ma'am, to deliver the vote of thanks. So, ma'am, you can take over from here now.
Okay. Thank you, Manoj sir, for a valuable session. Even though we had invited him in the last moment, he agreed to part of this FTP program, and he have shared his valuable thoughts and long years practical experiences in the field of legal pedagogy. As you told in your session, you have proved that a teacher should deliver his thoughts in an interesting way, just like a storyline. Thank you very much, sir. On behalf of Al-Azhar Law College, I would like to express my immense gratitude towards you. Thank you, sir. Thank you very much. For our in the part of the ending part of the 7 days FTP program, even though this is an online platform, we have eminent resource persons from international and national level from various reputed institutions. Each and every session was great. Legal research is not which cannot be separated from the legal teaching. By experiencing these valuable sessions of this FDP, we understand law teachers has to undergo some kinds of legal research. Students are required to be taught about formulating collection of data to highlight the importance of legal research and to be used as a tool for the legal research in the classroom. As our resource person, Professor Manoj sir explained in the session, whatever values we communicate to our students, that will be reflecting their future responses, their interactions with their society. He pointed out some examples and some misconceptions of the general public about the law and legal system with certain examples. That is nothing is permanent, like right and wrong, the field of law. That may be changed according to the person's or individual's perspective which handle those issues. A teacher should kindle the light of knowledge in the minds of students and delight them. I enter into the responsibility of deliver the vote of thanks for this event to all the dignitaries and eminent resource persons who handled each session of this FTP program. I express my sincere gratitude towards Dr. Bismi Gopalakrishnan Madam, who handled the inaugural session, and also to all the dignitaries who wanted to be part of this FTP program. I would like to thank the management of the Al-Azhar group of institutions and to our beloved principal, Dr. Lovely Palos Madam. Without her advice and guidance, this FTP will not happen. And I would like to thank our academic dean, Dr. Somashekaran sir, and IQSD coordinator, and the technical team worked behind the screen, and the conveners and the organizing committee members, LLM students. But lastly, but not least, for all the participants for making the FTP program as a great success. Thank you, Manu sir, once again. Thank you, one and all present here. Thank you. Thank you very much.
So thank you, ma'am, for delivering the vote of thanks. So I end this session by saying thanks to all, and I appreciate you all for taking the time for being in this program today. However, this is our last session, so you may all please leave the session. Uh, Thank you. Have a nice day.